So I'd really like to welcome Joe Jaramillo. He's a senior attorney for Housing and Economic Rights Advocates, HERA, where he provides advice and counsel to low to moderate income consumers on their debt and credit issues. He's advocated for consumer rights through direct services, public policy, advocacy, and litigation. He was born and raised in Vallejo, California, so he's a local, and he's a graduate of UC Davis and of UC Berkeley Law School. Joe, thank you so much for being with us today. We really appreciate it and look forward to hearing your presentation. So go ahead and take it away. Thanks.
Thank you, Beth. Let me go ahead and share the PowerPoint presentation. So I'm sharing the screen now. And Beth, can you just confirm that that's appearing?
Yes.
Great, great. All right, so we're going to talk about dealing with medical debt today, the legal rights and options. And I'm just going to go to the next slide. I'm going to go over the agenda, and then I'm going to ask Leah to help me with a polling question. So we're going to talk about the severity of the issue and the relationship between debt and mental health. The third topic is out of order, but we'll go into COVID-19 related issues first, and then talk about preventing medical debt and the charity care and discount policies that hospitals are required to provide to certain low to moderate income patients. And then we'll get into how to dispute medical debt. And at the end, we'll offer a list of resources that patients dealing with medical debt issues can turn to. So Leah, if you can please do the first polling question just to get a sense here of people's experience of medical debt. So do you know of anyone having problems in paying off medical debt? Feel free to include yourself if you're one of those. And I just wanted to see what the experience is out there based on what you all are seeing. Wow, okay, 88% say yes. That just shows the extent of the problem. And so we'll go to the next slide and see how that's playing out nationwide and in California. As you can see, nationwide, over 43 million consumers have medical debt on their credit reports, according to the Consumer Financial Protection Bureau. And medical debt accounts for more than 58% of debt reported by collection companies. So not only are people experiencing the debt with the hospitals in the first place, but a large number of these accounts are going to collections because people can't afford to pay them back. It's also the leading cause of bankruptcy, and 26% of households have had problems paying their medical bills in a recent survey. In California, 4.4 million adults have unpaid medical bills, which is over 14% of the adult population. And the median medical debt in collections is $740. And we've seen bills of a lot more than that in the cases that we deal with. Before we jump into the general issues of medical debt, I did want to just go over some key protections related to COVID-19 issues. So in terms of vaccinations, federal law requires all health plans to cover approved COVID-19 vaccines, and they can't charge co-payments or cost sharing. And under Medi-Cal and Medicare, the vaccines are also covered for free. And the Center for Disease Control, the CDC, prohibits charging patients for vaccinations and requires hospitals to vaccinate uninsured patients. In terms of testing, the Federal CARES Act requires all health plans to cover COVID-19 testing, both diagnostic and antibody testing, as well as screening for symptoms. And under Medi-Cal, COVID-19 testing, exams, and treatment are free, regardless of income or immigration status. In California, the COVID-19 Uninsured Group Program provides temporary free coverage for uninsured and underinsured patients. The list of requirements are there on the PowerPoint, but you have to reside in California There is no income or resource limit, and there is no citizenship or immigration status requirement. So this covers basically all testing and treatment related to COVID-19. And coverage begins or began and is available retroactively to April 8th of last year. And it will last through the last day of the 12th month from the application date, or when the public health emergency ends, the earliest of the two. So those are important, if folks are being charged for COVID-19 services, testing, or vaccines, that is definitely going to run afoul of these legal requirements. And they should definitely appeal that or seek legal assistance, and we'll talk about how to do that later. This is just information that might be helpful for your client base in terms of how to apply for the COVID-19 uninsured group program. Basically, you apply through the nearest provider that's qualified under the Medi-Cal plan. And you can search online for the nearest provider at this link. And you could also call the 24/7 Medi-Cal nurse line. The number's listed there. And there's a paper application to apply for it, and there's a link to where folks can get that application to apply. Here are other sources of coverage. The Department of Managed Care requires that plans have to cover screening and testing for free if medically necessary for essential workers. Plans may charge the usual cost sharing for those without symptoms or known contact with someone with COVID-19. And there's a fact sheet that you can access for that. And then for plans that are licensed with California Department of Insurance, which most are, the licensed plans must cover screening and testing and waive prior authorization requirements. And treatment for COVID-19 and related illnesses is covered by licensed plans. And basically, you should review your plan or contact your insurance for questions about cost sharing and charges for in-network or emergency care. And here's a link to the Department of Insurance for further information about those plans. Just want to make sure, was there any questions on that segment, Beth?
People are just asking if we're going to share this webinar, and so I'm putting our First Five YouTube channel up onto the chat. So other than that, we're doing okay.
Okay, just checking. Also, just wanted to emphasize the relationship between debt and mental health. Patients with debt are 2 times as likely to develop major depression, according to studies. And patients with depression and problem debts are 4 times more likely to be depressed when contacted 18 months after receiving treatment, compared to those with depression but no problem debts. So indebted patients are at a greater risk of physical and mental health problems, harms, and injuries. So dealing with debt and medical debt specifically can help people avoid these issues. Another study that's linked there from 2014 notes that the existence of debt, even in high amounts, is not necessarily a significant predictor of depression, but it boils down to perceived control over financial circumstances. So when people feel that they're not in control of their financial circumstances, that can be a significant predictor of whether they're going to experience depression or not. An intervention enhancing older adults' control over their personal financial circumstances may protect against these negative impacts of debt. So interventions including finding resources for them to try to manage or deal with their debt, which is what we're going to discuss here. So medical debt arises, the common scenario that we see at HERA when people come to us for assistance is that someone didn't have insurance, or their insurance had a high deductible, and they went to the emergency room for treatment, and they later get a bill for thousands of dollars. I'll give you one example. I had a patient, or a client, not a patient because I'm not a doctor, I'm a lawyer, but I had a client who went to the emergency room in San Joaquin County because he was experiencing a severe headache. And the ER ran him through a CAT scan, an MRI, and other tests. And at the end of it all, after several hours, told him that there was nothing wrong with him and he should just take Tylenol. And when he got the bill, it turned out that he was charged nearly $10,000 for that. And one of the problems you'll see is that he was not screened for his eligibility for a financial discount based on his financial circumstances. And so we helped him try to resolve that and apply retroactively for a discount under the hospital's discount policy. So that's a common scenario that we see. Medical procedures can be expensive, and they are billed at different rates depending on the patient's coverage. And traditionally, uninsured patients had been billed higher, and there are laws in place now that we'll discuss that try to protect that from happening. But unfortunately, even though they're required to, hospitals often don't inform patients of available financial assistance programs. And even if the patient is insured, their health insurance may have a high deductible, going as high, between, $1,000 and $5,000 deductible, to where they're responsible for paying for the treatment, the procedures that are not covered by the plan up until the amounts reach that deductible. And so one emergency room visit can put them in thousands of dollars of debt. And another common scenario is the patient in the hospital have a miscommunication about billing the patient's health insurance. And so the treatment is billed out to the patient and the health insurance is not billed, or they're billed, at the wrong amount, or the coding, the health coding for the treatment doesn't match what the patient actually received. And so they end up being billed for more than they should, because their insurance should have been billed, for most of it. And unfortunately, what happens if someone gets a hospital bill and they can't afford to pay it, and they don't get the hospital to, or they can't qualify, or the hospital wrongfully doesn't consider them for a financial assistance or a discount under their financial assistance policy, those unpaid hospital bills end up going to collections agencies. And those collections agencies try to collect, and they'll tack on additional collection fees and charges and interest, and sometimes even attorney's fees, which is usually not allowed, but they'll try it anyways. And if the patient can't resolve the debt, those will become debt collection lawsuits in court. So in terms of options for dealing with this problem, this is just a general overview, and we'll try to drill down in a little more detail on each of these. But number one, definitely check the billing for errors. These errors happen more often than you would think. As I said, someone may be billed for treatment they didn't receive. It might have been a wrong hospital coding, or there may be errors in terms of what should have been billed to the insurance and what the insurance covered. And so it's important to check the bill first and foremost. If the person's insured, check for what's called balance billing. And that's when a hospital bills patients for more than their health plan's copay or deductible. And this can happen when service is provided by an out-of-network provider, but recent legislation prohibits that under California law. So even if someone goes to an out-of-network provider, they should not be billed for more than their health plan's copay or deductible. Patients who have dual plans with Medicare and Medi-Cal, as many seniors often do, should not be billed any balance if the office doesn't accept one or either of those plans, because they should be paid for, because really Medicare or Medi-Cal should be covering those. And then, finally, as I noted before, and we're going to go into more detail on this because it's often the most effective way to deal with medical debt, particularly for people with lower incomes, is to check to see if the patient qualifies for financial assistance under the hospital's financial assistance policy. If someone is uninsured, they can still try to sign up for retroactive coverage particularly with Medi-Cal or Covered California or Medicare. And there are, we'll see in the next slide, I think, certain look back periods for those plans, so that it's not like they can retroactively be covered, till the beginning of time. But if it happened recently, they can apply for coverage, and if they're eligible, they should be retroactively covered in one of those plans. Can then pay the hospital, and then of course again check to see if the patient qualifies for the hospital's financial assistance under the policy. And for certain very low income individuals, they may qualify for county assistance as well under the health program of the county, which in Alameda County is known as Health PAC, and it provides health care for uninsured people living in the county for certain treatments, including emergency room visits, I believe.
Joe, there is a question.
Yes.
Somebody's asking, if a hospital or medical center doesn't accept Medi-Cal or Medicare, who pays the bill if the client can't be billed? So it's a question about.
Right, that's a good question. And I'm gonna have, this has only come up once with one of our clients, and one of my colleagues handled the situation, and I don't have a full understanding on who pays that bill, so I don't want to answer it out of hand. But it's a good question. But what we understand is if they don't accept one or either, they should not the patient should not be billed for the balance because they
can. Yep. I'll go ahead and hold on to that question, and then maybe I'll email you with that question, and we can then email the answer when we send more information to our participants. Is that okay?
That's fine. So let's go to the next slide. So in terms of checking the billing, hospital bills do often contain mistakes that you can dispute. In fact, it's estimated that between 30 and 40% of medical bills contain those mistakes. So here are some steps, to check for errors. Number one, definitely ask for an itemized copy of the medical bill, and the patient's medical records. The patient has the right to request their medical records and compare what treatment is reflected on the records with the bill. If something on the bill looks fishy, like it's a treatment that the patient doesn't recall receiving, a certain test or medication even, that is something that can be disputed, and maybe the medical records would provide evidence that the bill is inaccurate. Again, make sure that if the person is insured, that their insurance paid for what it should have paid for. And people who are insured, the health plans typically have a patient advocate office or like an ombudsperson, and you can call that office and have them review the bill and make sure that and tell them your problem, what you think the inaccuracy is. And sometimes the insurance itself will resolve that and communicate with the hospital and let them know that they should have coded the treatment differently, or they actually charged the patient for something that was covered by the insurance, and try to correct that. Sometimes you get the bill and there are only these medical codes that are provided that don't really tell you what treatment was provided. And so you can look up the codes on this. There's a guide here. There's a link to the verywell.com patient guide to medical codes, and that'll kind of decipher the codes for you so you could figure out what the patient's being billed for. And also the California Office of Statewide Health Planning and Development maintains a database of hospital charge masters, and the charge masters are the hospital's own coding that also lists what they typically charge for those types of treatments. And so the charge master database is linked here, and you can go on the database and download an Excel spreadsheet for the particular hospital. Now, that's not going to give you each and every code in treatment that the hospital provides, but it's typically the most common treatments and what the average charge for those treatments are. And sometimes you'll find that the patient was charged a lot more than what is listed on the charge master. And that would also be evidence that something is going wrong there with the billing and should be corrected. So if there were, sometimes also the patient may receive services because of the hospital's error, unnecessary services, or things that carry exorbitant charges. And so those are also things that can be disputed. So for patients that are uninsured, that are getting hit with a big medical bill, they should check to see if they qualify for retroactive coverage, either if they're potentially eligible for Medi-Cal or Covered California or Medicare. And for Medi-Cal, there is a 3-month retroactive period from the date of the application. So if they can take care of that fairly quickly from the time of their treatment, they might be able to get that retroactively paid for by Medi-Cal. So for uninsured, the other financial assistance programs available, as I said, there's the hospitals themselves have to have financial assistance policies. And so it's typically called charity care. And you can check this link to that Office of Statewide Health Planning to look up a particular hospital's fair pricing policy. And it will provide links for all the hospitals in the state that have to provide these financial assistance policies, which is generally most or nearly all hospitals in the state. And you can access the fair pricing policy to see if what the financial assistance is that is offered, and just to make sure that the patient is eligible. And most uninsured patients, well, we'll go over the eligibility in a minute, but a lot of uninsured patients will qualify for this, but often they're not even informed of it by the hospital. And so then they can retroactively apply for the assistance to reduce their medical bill. And then, as I noted before, there is county assistance available for subsistence medical care for indigent adults with no other source of care. And so in Alameda County, this is the Health PAC program. And if the resident's income is between 0 to 200% of the federal poverty guidelines, they should qualify. They also, have to be not eligible for Medi-Cal and not enrolled in private insurance. And these are services that are provided through one of 9 community-based clinics that are part of a network through the Alameda County Health System. So this is something, to also consider when people are facing problems with their medical bill. And let's go to the next slide. Just so you have a sense of what the current federal poverty guidelines are, and this is available from the Federal Department of Health and Human Services. But basically, this is the list here. If depending on how many people in your household, this is the maximum income that you would have. And so keep in mind for county assistance, it's 200% of this, so double. And you'll see that this is also going to be useful in determining if someone is eligible for charity care, because that one is generally 350% of the poverty guidelines to qualify.
So Joe, a question came in about whether there is a deadline for requesting hospital or county assistance for medical bill, as far as time when the bill was incurred, and then what's the time limit you have to request help. I wonder if that varies from hospital to hospital, or are there some kind of guidelines? Thank you.
Yes, that's a really good question, and it does vary from hospital to hospital. But our general approach is regardless of what the hospital's particular policy says, the eligibility for discounted payments or charity care can still be determined at any time the hospital is in receipt of income information. So if the hospital didn't receive income information at the time of treatment and didn't ask for it afterward, our position is that the patient should still be able to apply even months or more than a year later, so long as they're giving the hospital the income information that they should have asked for in the first place. So technically, yes, there are varying timelines, and I'm trying to think of some specific policies. I've seen timelines from 6 months after treatment to 1 year, and so they're kind of all over the map depending on the hospital. But our position is that if the hospital didn't ask for income information at the time of treatment or after, that the patients should still be able to apply at any time afterward by providing their income information.
Great, thank you.
So another question?
Nope, that's it for now. Okay. Thank you.
All right, thanks. So, and this is all provided for by the California's Hospital Fair Pricing Policies Act law in the Health and Safety Code of California law. And for short, it's also known as charity care. But it basically requires that hospitals have a discount in charity care policy for uninsured patients or patients with high medical costs, even if they are insured, who are at or below 350% of that federal poverty level. And as it's noted down below, the specific policies do vary from hospital to hospital. And I think, as I noted before, you can find the individual policies and the applications for those hospitals' charity care plans at this link. Many hospitals also have it on their website, but unfortunately, not all of them do. So this is probably, I usually go here to this link from the statewide Office of Health Planning. But you can also check the hospital's website or call the hospital and ask for an application and the policy. And this website is also good because it has a calculator to determine the federal poverty level to make sure that the person qualifies based on their income. And, just to kind of add clarity, this high medical costs for the people who do have insurance, that is when the annual out-of-pocket costs incurred by the individual at the hospital exceed 10% of the patient's family income in the prior 12 months, or annual out-of-pocket expenses that exceed 10% of the patient's family income if the patient provides documentation of their medical expenses paid by the patient or the patient's family in the prior 12 months. But it could also be a lower level determined by the hospital in their own policy. And so some policies do have more generous definitions of high medical costs. And other policies actually go beyond this. And I've seen at least one policy where if you were at 250% of the poverty level, you didn't have to demonstrate the high medical costs. So it's really important, to check the hospital's precise policy to see what they provide, and then be able to determine whether the patient qualifies for that.
So there is someone, Joe, that has their hand raised with a question.
Okay.
Are you open, Vina? Do you want to go ahead? I've allow you to talk if you wanted to ask your question. You can unmute yourself, I think, Vina.
I did have a question. If someone is at a nursing home, the rules may be different than someone in a hospital in terms of
that's a good
assistance. For example, I have a client who had to go to a nursing home. She was on Medicare. They applied for Medi-Cal for her, and she had a share of cost from Medi-Cal. We were able to negotiate with them to do a monthly amount, but her amount was almost $4,000. And the billing office, because of her share of cost, was like $1,700 to $2,000 a month, depending on which month they calculated. And she is left with a debt of $4,000, even though she has Medicare and Medi-Cal. So I'm wondering what assistance might be there in those circumstances. And thank you. And I'll take myself on.
That's a very good question. And this goes to what the definition of hospital is under this charity care law. And unfortunately, the definition does, it doesn't include skilled nursing facilities or intermediate care facilities, treatment centers, or hospice facilities. It does not include those, unfortunately. What it does include are general acute care hospitals, acute psychiatric hospitals, special hospitals, and facilities, your run-of-the-mill hospitals that are required to be licensed under California law by the State Department of State Hospitals or the Department of Corrections and Rehabilitation. So very important point you raised there, Vina, about the inapplicability of this particular law to skilled nursing facilities. And in terms of your question about how to deal with that debt, that's a very again, let's put that with the other question you took note of, Beth. We'll have to research.
Will do.
That. Yeah, because we haven't encountered that particular issue as far as I know at HERA. And so we would have to look into the options, but unfortunately the type of financial assistance we're talking about here with charity care does not apply to that. Just the other thing to note is income, is really key here to eligibility. And in terms of the hospital's consideration of income, the documentation that they consider that they must consider is limited to tax returns and pay stubs or other documentation of receipt of benefits like Social Security. So in terms of applying for charity care, it should be sent to the hospital, not the debt collector. So, a lot of times, like I said before, when someone doesn't pay their hospital bill, it'll get sent to a third-party debt collector, and then the letters and calls will start and continue. Even though it's the debt collector now that is communicating with the patient, it's really the hospital that considers the charity care application. And so it should still be sent to the hospital even when debt collection starts from a third-party debt collector. And in terms of the application itself, it's going to vary, like I said, from hospital to hospital, but it's just really important to complete the entire application. And if the application requests any additional documentation, which they all pretty much do, definitely include exactly what they're asking for, whether it be the income documentation or the insurance information. That's going to be key, because if it's an incomplete application, then your argument that you qualify is not going to be fully supported. always keep a copy of all documents submitted. I recommend that the person fill out the application, attach the documents, and make a copy of the signed and dated application, because that's proof of exactly what you've sent the hospital and what they had to consider in making a decision on the application. And then some hospitals let you fax in the application, so that can be done. But if it's going to go by mail, do it by certified mail with the return receipt requested. That will just further have it become proof that the hospital actually did receive the application in the form that you submitted. And we'll get to court litigation about hospital or medical debt later on. But if the person is being sued in court and they apply for charity care, we like to file a notice of submission of charity care application with the court, just to put the court in the party suing, which sometimes is the debt collector, on notice that the patient is seeking financial assistance, which had not been provided by the hospital. And that could be further evidence in supporting their defenses to the collection case, or even affirmative claims that they may have against the hospital and debt collector for not, giving them consideration for their financial needs in terms of trying to pay for a high medical bill. Additional protections for California patients include the following. In terms of emergency care, health insurance plans in California are required by law to pay for emergency care without prior authorization. And if the patient received the healthcare at an out-of-network provider, that is a provider that's not within the network covered by that health insurance plan, the plan needs to transfer the patient to an in-network health provider for further medical care once the patient is stabilized. There is a 150-day resolution period provided for under the law. So the hospitals need to provide underinsured and uninsured families with a 150-day period in which debt collection efforts will not occur. And so this time frame allows the patients to try to negotiate their hospital bills and medical debts if they're able to. And then, in the worst case scenario, if there is a lawsuit against the patient and they lose the lawsuit and there's a judgment against them for the medical debt, the medical debt collector is not allowed by California law to garnish a patient's wages or income unless they go back to the court and get a specific court order for that. So that's an additional protection, because normally in any other debt collection lawsuit in California, wage garnishment is one of the methods that the judgment creditor can use to collect on the judgment debt, but not with medical debt. I just here wanted to give you a visual of the Office of Statewide Health Planning and Development's website, and where you can look to find the financial assistance policies and applications. And you see here there's the federal poverty level calculator, so that you could determine the 350% and whether the family or a patient qualifies based on that. And then down below, you can go to each particular county and look for the hospital within that county, or you could run a search for the hospital here. And you can access the charity care policy and the application itself to be used for the patient to apply for financial assistance. So if someone's insured and they qualify for a discounted payment plan under the policy, then there's some additional protections that apply. So there's a rate cap, which means that the hospital cannot charge more than what it would expect in good faith to receive for providing services from Medicare, Medi-Cal, or the Healthy Families Program or another government-sponsored health program in which the hospital participates. They can choose, though, among that for whichever charges the most, unfortunately. But generally, that ensures that that people who are charged and might have to pay a certain amount because it's it's within their deductible when they're insured, that they're not overcharged, more than what someone covered by a government plan would be charged, which has typically been the problem for people that are insured but get hit with a large emergency room bill that's it's within the deductible, so it's not going to be paid by their insurance. The policy of each hospital also has to include an extended payment plan to allow payment of the discounted price over time. And so at a minimum, a reasonable payment plan is one where the monthly payment is equal to or less than 10% of a patient's family income for a month. In determining what the family income is, essential living expenses must be excluded. So it's not the gross income or even the net income, it's less than that, just to try to further ensure that this payment plan is going to be affordable for the patient. And the payment plan has to be interest-free. And so we've seen times when the hospital or the debt collector does not offer this payment plan at all, but tries to collect a lump sum or a plan, or a payment plan that charges interest. And so it's important that people know about their rights in this regard if they qualify for the discount policy. So when it does get sent to debt collection, these are the typical problems that we see. As I noted before, the debt collector is not typically offering a reasonable payment plan, but trying to collect more. We've seen instances where the debt collector is trying to collect on what is really untimely debt or time-barred debt. And so what I mean by that is basically that in order to sue somebody in court for a debt, there's typically a 4-year limit, which basically means that the debt collector or the creditor has to sue the debtor within 4 years of the time they defaulted on the debt. And the time of default on the debt is generally considered to be when they stop making payments, or if they never made a payment, the default would be the first month when the payment was due and they failed to make the payment. So if 4 years has passed and someone hasn't made a payment on the debt, then it's really too late for the creditor or the debt collector to file a lawsuit at court. That doesn't mean that they don't file these lawsuits. They still can file, and then the person has a statute of limitations defense. But in most, they can try to get the case dismissed because of that. But in most cases, there aren't lawsuits at that point in time, but the debt collector continues to send letters, threatening letters, that they have to pay the debt or they may face a lawsuit, continues to call the person and try to get them to pay. It's really, it's okay for them to try to collect on the debt even when it's time barred, because just because the 4 years has passed doesn't mean that the debt just disappears or is forgiven. It just means that they won't be able to sue in court. The problem is when they make threats about filing lawsuits or taking legal action against them. And really what they should be doing is informing them that, the time limit to file a lawsuit is passed, but they still owe the debt in the creditor or the hospital or debt collector's opinion, and asking them to make a payment on the debt. But that typically doesn't happen, and people will still get these letters 4 years or more after the default, trying to collect on the debt. So, it's the main point here is that if that is happening, the patient needs to know that they should not have to worry about being sued in court. And if they're being threatened otherwise, that is unfair debt collection, and they might even have claims against the debt collector for that. Another thing that we see is that even though the 4 years has passed, the debt collector or the hospital can still report the past due account on credit reporting, generally 7 years after the default. So what they'll do is, even though they can't sue them in court, they'll keep it on the credit report to try to, use that as leverage to get the person to pay, which sometimes a person wants to have good credit. Who doesn't, right? In order to qualify for rental housing or for an auto loan, a mortgage, a student loan. And so that is often used as a means of debt collection, continuing to report it. And so the key there is for people to review their credit reports and see what's on there and see if anything about the reporting is inaccurate. Are they accurately reporting the payment history on the account? Or is the amount being accurately reported? It may be that they have copies of old bills that show a lesser amount. And if this is an account where they applied for financial assistance or were on a repayment plan, that may be appearing differently on the credit report. And so there might be room to dispute the debt and get it off the credit report. And that could be done with a credit report dispute letter to the credit reporting agency and to the furnisher of the account being reported, which could either be the debt collector or the hospital. A lot of times debt collectors represent that they're assigned the debt or that they now own the debt. And that may not necessarily be the case. The hospital typically maintains ownership of the debt, but they've just basically hired a debt collector to try to collect the debt for them. And by hiring, they may not be paying the debt collector anything. It might just be that the debt collector will get a percentage of whatever they're able to collect for the hospital. And so if the debt collector is now representing that they're the owner or the assignee of the debt, that's also inaccurate and a form of unfair debt collection. And the way to kind of get to the bottom of that is, if the patient is really concerned about the debt collection in the letters and the potential for being sued, they can contact the hospital, or an advocate like HERA can help them contact the hospital. And again, ask if this debt is the hospital's or the debt collector's. And also, as I'm going to keep pointing back to, see if they can retroactively apply for financial assistance. And again, no matter what the hospital says, I generally recommend submitting that financial assistance application regardless, because there is a good argument if the hospital failed to consider their income and financial situation at the time of treatment, that they have to consider the application anytime afterward when the patient provides that information.
So Jill, there's a question about, can medical debt be considered in someone's credit report when they're being screened for housing? So this person has heard conflicting information about whether or not this is legal. Any thoughts about that?
Yes, I think generally, if it's like collections accounts, for example, can be reported to the credit reporting agencies. And so then the question is it being reported accurately? So that would form the basis of a dispute. Typically, we don't see, and I don't know if it's in this person's case or the situation that the person asking the question has seen, typically we don't really see hospitals themselves reporting the debt. And so, there might be an argument that if the hospital reported the debt, that wasn't really a credit account. It was a bill for services, but they had not established an account where they were borrowing money and paying it back, like in the traditional sense of a consumer credit transaction with a student loan, auto loan, a mortgage. So in that situation, I think there's an argument that the hospital should not be reporting the debt on a credit report, but collections agencies generally are allowed to provide or to report the collections accounts on the credit reports, unfortunately.
Thank you.
Yeah, it's a strange distinction because, you know, this also comes up with cell phone bills and like cable bills, and those things are generally not reported. But when it goes to collections and the collection agency is trying to collect for those unpaid debts, those are allowed to be reported generally. Sometimes we see multiple collectors trying to collect the same debt. And so that is a big issue. There should really only be one collector. And so it may be that the hospital hired one collector and then wasn't satisfied and then went to another collector, but the first collector is still trying to collect the debt. And so that's definitely a situation where something is wrong, and one of the collection agencies is engaging in unfair debt collection. And so that's something that we can help people resolve as well. But it's a matter of really, again, going back to the hospital and asking them who represents you in this, who's collecting on your behalf and who's not, because the patient's getting multiple bills.
Great, thank you, Joe.
Yep, sure. So then, you know, just some more common issues. There may be false statements about the debt in terms of the amount owed or the treatment that was provided. And so those, again, are things that need to be clarified. In my experience, the debt collector is not helpful with that. It's really, again, I keep pointing back to this, but I think if there's one thing to take away is keep going back to the hospital and trying to hold them accountable and telling them what their debt collector is doing, and trying to get an accurate read on what the actual you know, billing was and what it should have been. So if there was a denial of insurance coverage for treatment and it was medically necessary and that is appealed by the patient, there should be no collection going on during that time period, during that appeal period, until there's a decision. And so that's another practice that we see that we try to help people with. And then, you know, another thing to consider is a lot of medical debt is not really even a contract-based debt. And that's an important distinction because someone goes into the emergency room visit and they're basically signing a form that allows the hospital to provide them treatment. And it might have certain other provisions, you know, waiving certain liabilities if something goes amiss. But generally, it's just you know, it's like an entry form to the hospital. And a lot of times when there's debt collection on medical debt, the debt collector will point back to this hospital admission form and say, this was a contract. And because it was a contract, you know, under California law, if you sue under a contract, you're allowed to collect attorney's fees. And then they'll threaten to collect attorney's fees if they win the collection case, which is just more intimidation of the patient. And they're not allowed, our position is that admission form is not a contract. It's simply a form of admission to get treatment. And so the debt collector should not be able to seek attorney's fees based on that. And generally these admissions forms do not have any provision for attorney's fees themselves. And so that's a common practice that we've seen the debt collectors engage in. And even when they sue in court, they'll ask the court for attorney's fees. And they're really unauthorized and should not be awarded by the court because you need to have a specific contract provision that provides for them. So in these situations, you know, again, I'll just keep saying it. The general strategy is go back to the hospital. If the patient qualified for charity care at the time of treatment, and even at the time of collection, you know, there's an argument that they should be allowed to apply for a reasonable repayment plan or the discount that's provided for under the policy based on their financial circumstances. And then in addition, in terms of dealing with a debt collector, it's one of the important things is to try to dispute the debt as soon as possible, but definitely if it can be done within 30 days, that forces the debt collector under federal law to cease collections and verify the debt with the creditor, which in this case would be the hospital, and then provide that debt validation or verification to the consumer. And that's under the Fair Debt Collections Practices Act. And there's also a state law called the Rosenthal Fair Debt Collection Practices Act that would apply to this. And so disputing, go ahead.
Sorry, there's a question about,
That's okay.
Instead of paying the debt collector, can a bill be paid directly to the hospital or the physician? So I'm assuming this is debt that's already been sent to collection. So then can the consumer go, or the patient go back to the hospital or the doctor, or do they have to go through the collector?
Generally, I think it's a good idea to go back to the doctor or to the hospital and try to pay it directly, because that ensures that the debt collection, is the debt collector itself, is probably going to be, like I said, be seeking other things like attorney's fees or collection charges. And so that kind of ensures that you're dealing with the debt straight from the source of the debt. The only sort of tricky issue is you want to confirm first that the hospital is still claiming that it owns the debt. In some cases, hospitals may be trying to sell the debt to a third-party debt buyer, and so if they have transferred ownership, then you don't want it. It might complicate things then to still pay the hospital. But in most cases, medical debt, in our experience, is not really being sold to third-party debt buyers. It's being sent out for collection. And there's an arrangement between the debt collector and the hospital. And if you go back to the hospital and apply for charity care, they will generally accept your application. They may not, they may not approve it and give you charity care, but they will receive it and they will confirm, what the balance is. And once you have that hospital telling you what the balance is, that shows you that they're still claiming that they own the debt. And so you should be able to pay the hospital the debt amount, or try to work out some plan if you're denied your charity care application.
Great, thank you, Jill.
Sure. And then even if it's more than 30 days after the debt collection, we still recommend sending that letter. If there's any basis to dispute the debt, or even just to ask for the debt collector to validate the debt, verify what the debt is, and that the amount you're seeking is actually owed, because that will put a pause. And if it's after the 30 days, they don't necessarily have to stop ceasing collections, but it might get you more information from the debt collector's perspective as well. And so the more information, the better. And if you get conflicting information from the hospital and then the debt collector on the other hand, then that also is sort of a sign that there's something fishy going on and you want to dig deeper and try to get to the bottom of it. And then that might provide you even further basis to try to negotiate some sort of discount or payment plan. So I sent out some materials that included a sample debt validation letter, but this is sort of another sample here, especially if the debt, sometimes people are getting collected on debt that's not theirs. And so this is an example of of the letter I was talking about before. But something like this can be sent even if the person recognizes that they do have a debt with the hospital that the debt collector might be trying to collect on. It's just basically, it's the debt validation letter, and you're asking the debt collector to mail the documents that show that they think show that the patient owes the debt. And so this is kind of a template to ask for that information and to put any basis of a dispute about the debt. But I believe in the materials that I've circulated, the first 5 that hopefully you all can get, there is a sample debt validation letter that you could use as a template, to customize, or the patient can use. This is just a note. Another problem that can arise from medical debt and other forms of debt is people will turn to financial relief companies, many of which are scams, and just make the situation much worse. And so this is just a red flag to try to avoid this situation. There are companies called debt settlement companies, and they'll claim that they can reduce the amount that you owe on your debt or credit accounts. But many investigations have shown that these are false promises, and there are big risks and harm that can result to the consumer because of this. They'll usually ask you to pay a monthly fee, and then to stop communicating with the debt collector or the credit card company. Let us handle it, and we'll reduce your debt. But typically these fees, the monthly fee that you're paying, is not going to pay down your debt, but it's going into the bank accounts of the debt settlement company. And then when you stop paying your bills, then those accounts can tack on late fees, and those accounts will start their own collections. That you'll start getting collection letters, and it's a false promise to say that a debt settlement company can 100% reduce your debts, because once you default and stop making payments, the creditor does not have to reduce the debt. That would have to be some sort of voluntary arrangement or settlement. And basically, I think a lot of what these companies are doing, they're trying to negotiate a lower payment. They're arguing the consumer's financial circumstances don't allow them to pay, what is owed, and they don't. And if you sue them, they're not going to be able to pay that. So why don't you just reduce the amount now? And that may work in some cases, but in the meantime, because the consumers stop making any payments, it's hurting their credit score, because their credit report is showing all these missed payments. And in many cases, the company's not able to leverage any kind of reduced amount on the debt. And so, this typically happens when someone has a whole bunch of debts, like 5 or 6 accounts, and maybe they've been able to work something out on 1 or 2 accounts, but then there's 4 or 5 other accounts where the person's not making payments, and the late fees are getting tacked on, and it's leading towards several debt collection lawsuits that could be filed against them. So, but then when you get sued, the debt settlement company is not going to be there to represent you, and you're on your own. And HERA helps people, with help defend themselves in debt collection lawsuits. So we're certainly a resource that could be turned to, and our services are free for that. But a debt settlement company is just generally a bad idea. And there are HUD approved, the Department of Housing and Urban Development, HUD approved agencies that provide credit counseling services that are available. And I'm going to have a link later on to show you where to find those. But those are generally better. They're nonprofits. They typically do not charge anything for their services, and they can provide better advice on how to deal with these debts. And HERA certainly is available to do that as well.
That's great. Another question came up about you're working with elderly parents or a spouse. Is it wise to get a power of attorney or medical power of attorney so that you can then work with collectors on their behalf? Is that all? Will the power of medical attorney be enough to help you work on there, or do you need something else? Do you need to be, I'm not sure what's needed.
Right. So if you're assisting somebody, or when HERA assists somebody and we're not, representing them in court, what we get is a third-party authorization form. And the third-party authorization form basically just, if I could provide a sample if somebody wanted to see one at a later date, but it generally it's less all-encompassing than a power of attorney. But it basically is the consumer's authorization to let us communicate with the debt collector and or the hospital on their behalf. And that's generally enough to allow communications in terms of trying to negotiate, you know, a settlement workout with the debt collector, or to assist the person with a charity care policy. But generally, we try to just help the patient fill out their own forms, and we can review them and have them submit the charity care policies themselves. And there is a cover letter template that I also circulated in the materials for sending the charity care policy to the hospital. And that's generally, there's generally not a great need if the person is able to communicate and understand the paperwork, you know, with our assistance. But if it, you know, sometimes it is necessary when if someone has certain circumstances that don't allow them to you know, communicate freely. And if they want our assistance, there is this third-party authorization form. Now, in terms of medical records, that is a different form that's required. The HIPAA law, the health privacy protection law that's contained in federal law does have its own specific release in order to get medical records. We generally, when that happens, we'll just have the patient fill that out and request the medical records themselves, but they can also authorize someone else to receive the records on their behalf, but it has to be that specific HIPAA medical release. An advanced medical care directive is not required for this kind of assistance, nor is a power of attorney. It's just the third-party authorization would be one form, and the HIPAA medical records release. But again, these are things that we generally prefer to have the clients fill out and submit on their own behalf, and then we provide them with the counseling on how to deal with that, because it takes out us as a sort of a middle person. But you know, when it does become necessary to jump in and try to negotiate on their behalf, we certainly will use those forms to do it.
Thanks, Joe. I'll add that to the list that maybe we'll try to get from you a sample third-party authorization form. So thanks.
Okay. So this is sort of a flow chart on what happens, you know, when someone in debt collection in general, when someone doesn't, someone becomes delinquent on their account and is not able to work anything out, it ultimately can lead down the path of a judgment, as I was talking about. And so, you know, the borrower or the debtor becomes delinquent when they're late on a payment. And in general consumer cases, like when there's a lender, they'll report it, the debt, as a loss for accounting purposes after 120 to 180 days, depending on the type of debt. So they'll charge it off. That doesn't generally happen in medical debt cases, but this is sort of just your general debt collection timeline. So when they charge off the debt, that does not mean that the borrower or the debtor is forgiven of that debt. That just means that the creditors charge it off for their own accounting purposes and might entitle them to some sort of tax write-off. And then, you know, sometimes they'll sell it to a debt buyer, and that's the new owner of the account, although they might not be able to prove they're the new owner. And that's something we help people with to try to defend against debt buyers. Or it could be assigned to a debt collector for collections, which is the more typical scenario in medical debt. And then the debt buyer or debt collector will try to collect on the debt through phone calls and collection letters. And if that doesn't work, that could lead to the lawsuit, where the person is actually filed in a case is actually filed in court seeking payment of the debt, and sometimes interest and late fees, and possibly attorney's fees. Although, like I said, in medical debt cases, we don't think that's generally proper for them to seek that. And so you know, and so this generally, there's generally a 4-year time period for written contracts. If it was a verbal contract, which, you know, in medical debt cases, they might be able to have a stronger argument that there was a verbal contract to pay for treatment, because the medical admissions forms might not necessarily rise to the level of an enforceable contract. Then the time period is actually 2 years to file the lawsuit. And then so during the lawsuit, if it's under $25,000, it's called economic litigation, and it's a more streamlined approach where it generally there can be an exchange of information through discovery, document requests on both sides, and then it'll go to a quick trial before the judge, and then the judge will decide if the debt is owed or not. If the judge decides that the debt is owed, then that'll lead to a judgment, and that's where the collections can then become involuntary, in the sense that once there is a judgment, the creditor can ask the court to, you know, for an order, so the sheriff can then levy the bank account of the debtor to try to collect fees to pay off the debt. And as I noted above, in terms of medical debt, wage garnishment is not allowed unless there is a special order of the court, where the court's informed that this is medical debt, but nonetheless, the creditor is seeking to garnish wages. The other thing that can happen is a lien can be placed on the property of a judgment debtor, and that lien would be paid off when there's a sale of the house. And generally, if the lien is, you know, is under, if it's not a significant amount of money, for example, if it's under $75,000, then that's not going to lead to like a court-ordered sale of the house. And there is a homestead exemption for homeowners as well, that a certain amount of their equity in the house is protected from collection. So medical debt cases, in our experience, generally would not lead to any kind of court-ordered sale. In fact, I think there might be a protection even against certain property liens. But again, the bank levy is sort of a main threat here when there's a judgment for medical debt patients. So in terms of medical debt litigation, we try to help people with this as well, and we've represented some medical debt defendants, and we've also helped others represent themselves. So the important thing is, if someone receives a summons and complaint, usually by personal service, or sometimes it's left with somebody, an adult 18 or over, at their home, and then it's mailed, they have to respond within 30 days if it was personally received, and within 40 days of mailing if it was left with an adult and then mailed. It's really important to get legal assistance to know how to respond to this because of that time limit. You know, there may have been problems with service if they actually were not served, or if it was left with a minor. And so they might be able to file, we can help people file a motion to quash the service and require the plaintiff to serve them all over again. Or, you know, they may have strong defenses or valid defenses to the debt collection, such as not being informed of their right to charity care, not being considered for financial assistance when they qualified, or not being considered for county assistance when they qualified. And so those are defenses that can be put in a response, generally called an answer. And that, again, has to be filed within a certain time period, whether it be 30 days after personal service or 40 days after the what's called substitute service, when it's left with an adult at the household and then mailed. And we generally help people with that. We help them for free. We typically, because we can't represent everybody, we help them with the forms, and filing the forms and serving the forms. but they're still representing themselves. But with our assistance, we can generally help them deal with this and either try to work out a settlement or successfully defend against the medical debt. So just the main takeaway here is if you have clients that are facing this, getting sued for medical debt or any kind of debt, really, we're definitely a resource to help people on defending themselves in these kind of cases. Sometimes the collection activity could give rise to affirmative claims against the hospital or the debt collector. And so they can also file a cross complaint. If that were the case, that might be a case where HERA would step in and represent them as their attorneys in court, or maybe we could find another attorney to do that for them. And this could be the case, for example, where they were not provided the opportunity to apply for charity care, or they're being overcharged, or they were denied county assistance when they actually qualified. So it just depends on the circumstances. It's not going to be every case, but they might actually have affirmative claims to go after the debt collector or the hospital. Oh yes, so the last point here, in terms, I was talking about judgment. You know, hospitals can't use wage garnishments, as I noted. And just to confirm, because I think I was a little unclear on the last slide, they also cannot put liens on primary residences to collect unpaid hospital bills. So that's another protection. So really, it's the bank levy that's the risk, and you know, where a judgment creditor can get the court to issue what's called a writ of execution of judgment, so that the sheriff can go in and do a bank till where they pull money from the defendant's bank account in order to satisfy the judgment. There was a new law put into place. I think it took effect last year. And so there is a certain amount of funds in a bank account that is protected. And I can't recall the exact amount at this point, but it's intended, you know, you don't want a situation where somebody's bank account is just wiped out and they can't afford to pay the rent or their mortgage and their basic life necessities. The other thing is, if someone is going to have a bank levy, they have to get notice of the bank levy, and they have 10 days to respond with a claim of exemption. And the claim of exemption can either you know, assert that the funds in their bank come from a protected source of income, and that includes government benefits like Social Security, SSI, and other public assistance, and retirement. Or even if the funds in the bank are not protected because of that, they can submit their financial budget, and if they can show that the bank levy would result in them being unable to afford their basic life necessities, then that could also provide protection from the bank levy. And then that goes to the sheriff, and then the onus is on the debt collector or the hospital to go back to the court and argue against the claim of exemption. And sometimes they won't; they'll just drop it, and then the person's protected, at least for that particular attempt to levy the bank account. But unfortunately, the judgment creditor can come back and try again at a later time, as long as that judgment's in place. Sometimes people come to us and they have a judgment and they didn't even know about it because they were never served. The service was on an address that they hadn't lived at for several years, or it went to the wrong house. And so they never had notice of a lawsuit. In those instances, we could try to get the judgment set aside and reopen the case, which would protect them at least temporarily from these kinds of collections, and would also give them an opportunity to try to argue against the debt for some of the reasons that I've explained above. So, I mean, generally, when there's litigation involved, the patient needs to get legal assistance, and HERA is one resource for that. And speaking of resources, here's a list of other resources that can be turned to. You know, many health plans have their own patient advocate centers that as I mentioned before, they can help people find in-network doctors and dispute hospital and doctor charges. You know, sometimes a doctor may charge you for your annual physical, but the annual physical is actually covered under your plan. Maybe they coded it not as a physical, but as like a routine office visit, for which they can charge. And so when you get your health plan's patient advocate involved, they can often help you reverse that charge. Again, you know, I've said it before, but the Alameda County Health Pack is the county healthcare plan for uninsured residents within 0 to 200% of the federal poverty level who are not eligible for Medi-Cal and not enrolled in private insurance. The two government agencies I mentioned above also have complaint hotlines and complaint forms that could be filed with them to investigate issues in accessing care for COVID-19 or issues about denial of coverage, billing problems, and claim and copay disputes. So for COVID-19, the Department of Insurance is you know, probably the best place to start for COVID-19 type issues in terms of coverage. But for generally, you know, health plans are also regulated generally by the Department of Managed Healthcare, and they have this dispute help center that you can call. And there's also an online portal to file a complaint that's listed here. And then, you know, legal services nonprofits like HERA, other folks might be eligible for legal services corporation funded agencies like Bay Area Legal Aid, East Bay Community Law Center. These are legal services agencies that could try to help people with these types of issues, particularly if they're getting sued or if they're facing aggressive debt collectors. They can also turn to HUD-approved counseling agencies, and here's a link here to a list of those in California. There are a number of credit counseling agencies that are approved by HUD. They're nonprofits, and they can help you work out a plan to try to deal with your debts in a way that doesn't, you know, make you worse off like a debt settlement company will. And then finally, I'm going to go to the next slide, but the Health Consumer Alliance is a nonprofit that's dedicated to these types of issues. And they're a good resource to turn to as well, especially for particularly complicated issues. And so here's a visual of their website, but they offer free assistance over the phone or in person to help people who are struggling to get or maintain health coverage and resolve problems with their health plans. And so, you know, they provide free confidential consultations, including people that are concerned about, you know, Medi-Cal because of immigration status or any other reason. So this is a good resource as well. Of course, for uninsured folks, they might not be the best place to turn to, but again, folks can come to, can consult with HERA or other legal services agencies, as well as the HUD-approved counseling agencies. Let's see where we're at. I think, Leah, it's time for our last set of polling questions.
And we're almost at 11:30.
Oh, okay.
Yeah, so, yeah.
Yeah, I'll launch the first poll.
All right, so this is kind of, you know, true or false questions to see if I was able to convey to you this information effectively. But true or false, patients with health insurance cannot qualify for the discounted payments or charity care. And the survey says false, 100%. You guys are great.
Woohoo!
Wow, I'm impressed. All right, next question.
You should be able to see the next poll.
True or false, a hospital can collect on a medical debt judgment by garnishing the patient's wages. All right, false 90%, true 10%. So it is false. They cannot garnish patients' wages. They can still try to levy their bank accounts. And Fortunately, but for the one person that said true, they are partially correct, because there is a situation where wages can be garnished, and that is when the judgment creditor goes back to the court and says, this is a medical debt case, but I have a special reason to garnish this person's wages. And with the court's permission, they can. So even that, the 10%, or I think it's a one person who said false, well, there's some truth to that answer as well. So everybody's really correct on that one. All right, last question. True or false, a debt settlement company is generally the best way to reduce the amount you owe on a past due account. So the answer is false on that one. That is not generally the best way to reduce the amount you owe. I guess it's conceivable they could, but you really want to go to a HUD-approved credit counseling agency, a nonprofit, because debt settlement companies will generally charge you. They'll make false promises that they can actually reduce the debt, and there's really no guarantee that they can. Okay, so we've got 1 minute, and any further questions before we wrap up?
No, people are just really appreciative of this information, Joe, and we're gonna work to make sure people get all the links that are in the PowerPoint. So yeah, I just want to thank you so much for being here, and any of these anything you want to say about these closing pieces here?
No, I just want to thank you all for your interest in this topic, and please don't hesitate to consult with HERA if you or your clients have these kind of issues. You can reach us here at the number listed below in our website, and there is an intake line, which is extension 300, and the person can just leave their name, phone number, and a brief description of their problem, and someone will call them back within a week or so to schedule a consultation with an attorney if it's something that we can handle, or to refer them to a better resource. And this is just a general list of our services, as you can see, ranging from debt collection to credit reporting issues, foreclosure prevention. We also, it's not listed here, but we also are helping tenants with pre-eviction issues, but not eviction defense. And we do provide estate planning help on simple wills, trusts, health directives, and powers of attorney. That is the only service that we charge for on a sliding scale based on income. All the rest of our services are free. Thank you very much, and good luck with everything.
Thank you so much, Joe. We appreciate you being here and sharing all this great information. And thanks to everyone who came today. You will be getting a link to the recording when we have that up on our website, and some of the other resources that we have mentioned here. Some people said some of the links that they found weren't working, so we'll see if we can try to send those live links out for people. So again, thank you so much for attending. And Joe, thank you